We are from Davis Law School and we're going to talk about economic laws. My name is Shakira and these are my group members.
Hi, I'm Sam. Hi, I'm Nico.
Hello, my name is Prabhu.
Hi, I'm Sharvana. We hope you enjoy our video.
Konnichiwa minasan. Today we are talking about the definition of economic laws. Economic laws is a financial laws, both consequential and pure. While consequential economic losses are losses incurred as a result of physical injuries or damage to property. Pure economic loss, on the other hand, is other losses that follow which do not follow from the damage independent from it. There are a lot of things that I want to talk today about pure economic loss. First, there are some laws. Pure economic laws is defined by each country that they are originate from. There are laws that are followed by Malaysia, England, and Australia, and other Commonwealth country, and plus the United States. And on the other hand, there's the civil law that is followed by Sweden and Germany specifically. In the case of Spartan Steel, the main argument in this case is not all financial losses are recoverable in tort. Pure economic loss is a special type of negligence that may not be recoverable or may be. When a claim is brought in tort of negligence, it is generally brought out of two reasons. One, the claimants may have suffered damage. Two, the damage may have financial consequences or loss of profit. For example, a loss of profit. However, there are sometimes losses that do not occur because of damage, but simply are just because of losses. For example, someone may buy a new TV in the few months down the line, the TV may be malfunctions and catches fire a lot. That fire damage the other properties in the house, like for example, a game, or maybe your own wooden table, yeah, or carpet. But supposedly that the same TV malfunction, but this time there is no damage. The TV just does not work. There are no pictures or any sound. In the above case, the first loss is a consequential economic loss. A TV has a fault. The fault causes fire, and the fire causes damage around your house. Whereas the second scenario is a pure economic loss. The fact of this case is that the claimant was a steel factory, and the defendant was a contractor who negligently cut an electricity supplying cable, which resulted in the power cut to the factory. As you can see, this meant that the factory was temporarily closed for 14 hours and was not able to produce any metal while there was no more power. The factory also did not have the power to power its furnaces, which were in the process of melting steel. That was sad, really sad. And the metal and then solidified, meaning it's not longer useful at this time. The claimant brought a claim of negligence that argued they suffered three types of losses. One, losses due to solidifying metal, physical damage to the property. Two, loss on the profit that the factory would have made when the metal got solidified, meaning no longer useful or useless, let's say, in better terms. Three, there are the loss of profits that the metal and the factory could not produce while it was temporarily shut down. The court allowed those first two claims. On the first claim was for a loss that arose due to the damage to the physical property. Yeah. The second claim was allowed because it was a consequence to the damage to the physical property. The court, however, did not allow for the third claim, which the claimant argued for the loss of profit they would have been making had the processing metal not been interrupted. The court classes the third claim as a pure economic loss. It was a potential profit but did not occur because of a damage.
A tort can be described as an act or omission that results in a civil action against the party
that committed the wrong act in a court of law. The tort of negligent misstatement is described as an incorrect declaration produced sincerely but carelessly, generally in the form of guidance provided by a party with a unique skill or knowledge to a party that does not possess the skill or expertise. To demonstrate that negligent mistake has happened, we must demonstrate that negligence components have been infringed, as most torts have prevalent components that include duty of care. In order to claim negligence, a person or party must owe the other person or party a legal duty of care. Since it is the complainant's responsibility to prove that there is a duty of care between the parties, he or she must tackle the four-stage test. Firstly, was it fairly predictable that one's behavior would be harmful? Secondly, standard of care. This standard is what we think would be observed by an ordinarily prudent person. We need to deduce what a reasonable man would do. The third facet is to consider actual damages caused. And the fourth element to prove would be existence of a special relationship. To create a claim for negligent mistake, we must demonstrate that at the moment of the tortious act, fundamental components of negligence existed in relation to that special relationship link. A core case would be Hedley Byrne and Co. Limited, v. Heller and Partners Limited. Hedley Byrne was advertising agents on loan terms that placed agreements on a client's behalf. In case of the client default, Hedley Byrne would be personally responsible. Hedley Byrne told their lawyers to receive a credit reference from Heller and Partners, the bankers of the client, in order to safeguard themselves. The reference, both orally and then in writing, was provided free of charge and was favorable, but it also included an excluding clause to the impact the data was provided, without accountability on the part of this bank or its representatives. When the client came to liquidation, Hedley Byrne depended on the reference and eventually experienced economic loss. The court discovered that the disclaimer of Heller and Partners was enough to safeguard them from responsibility, and the request of Hedley Byrne failed. However, the House of Lords held that the compensation for pure economic loss could occur in cases where the following four conditions were met. A. A fiduciary relationship of trust arises or exists between the sides. B. The party preparing the advice or information willingly took the risk. C. The other party relied on the advice and info. And D. Such trust was reasonable in those circumstances. In 1963, however, the House of Lords created that pure economic loss could now be recovered in English legislation in restricted conditions. A negligent mistake may lead to a financial loss damage intervention. A duty of care will be implied when a party seeking data or guidance from another, possessing a unique ability, and trusts him to practice due care, and that party knew or should have known that the first party relied on its expertise and judgment. Other kinds of economic loss claims were attempted and sometimes successful in the years after Hedley Byrne. A culmination in Annes v. Merton London Borough Council, where the court held that negligent supervision by a council arising in cracks on a construction from insufficient foundations amounted to physical material damage. Instead of pure economic loss, damage to repair expenses could be recovered. This case was pursued 5 years later, before this decision was overruled by significant change in the legal climate. The House of Lords also refined the Hedley Byrne test in Caparo Industries v. Dickman. In a case of misstatements, Lord Bridge laid out 3 demands to be discovered before a connection of adequate closeness would be formed. In Caparo itself, it was not sensible to rely on the data because it was provided for one reason and could and should not be used for any other purpose. Henderson v. Merit Syndicates set out the present test for assuming responsibility. Despite the Caparo ruling restricting the circumstances in which a duty of care would occur in relation to pure economic loss, it was in reality expanded by some subsequent choices. Hedley Byrne opened the case for action outside the contract law for loss based on a statement's dependence. In the 50 years since the decision, there have been significant fluctuations in its application, but it has opened the door to liability for negligent statements made by those in a trust capacity and beyond the wider area of professional services.
Hi, I'm from Swan Developers.
Oh, hi, I'm Shakira from Delco Council.
I would like to show you a house that I just built.
Alright, let's see.
So this is the house I just built.
I see. Wow, this is such a nice place. It looks perfect.
I was wondering if I could get your approval on this.
Yeah, it looks not defective, anything, everything's just perfect.
Yeah.
Sure.
3 days later.
Mr. Burby, this is the house that I built.
Oh, it's a very nice house. I would like to buy it.
It's yours, deal.
Yeah.
One eternity later.
Mr. Praveen, I'm Samuel. I saw the advertisement that you are going to sell a house. Is it possible for me to visit your house?
Hi Samuel. Yeah, you can come here and look at the house and make your decision.
A few moments later.
Hi, Mr. Praveen.
Oh, hi Samuel.
Yeah.
Have a look at my house.
Wow, this is a nice one. I like it.
So, do we have a deal here?
Deal.
Yeah, let's.
Tomorrow for sure.
Hello, good sir. I'm your
Hello, sir.
allow you for your purchase. So,
So what do you have
you
to
guys
do?
need to sign this contract.
Yeah. So, that's the deal, yeah?
Yes.
Alright. Thank you very much.
See you later, my friend.
Yeah, you too.
3 weeks later.
Finally, I have my own house. This is a defective chair. I'm going to sue Mr. Praveen.
Hello, Mr. Samuel. I heard that you were hurt. How are you?
I'm going to sue you for the defective chair.
But you cannot sue me. The developers were the one who built the house and the furniture.
I'm going to sue the devil.
Hello, is this
Hi.
Swan Development?
Hi, Mr. Praveen. What brings you here?
My friend was hurt because of the defective item in my house because he bought the house from me.
Okay. You can't sue me. You have to sue the city council. Hi, Ms. Shakira.
Hi.
You're
What
from the
brings
local
you-
council, right?
Yeah, I am. What brings
So-
you here?
We're all going to sue you because you approved the house and it turned out to be faulty, which caused injury to our friend here.
Oh no!
Hi, my name is Samuel. Today I'm going to talk about pure economic loss claim for defective properties. First, we have to ask the question whether the purchaser can sue the negligence builder who was responsible for the defects. The person in the street will probably ask, why not? If I buy a washing machine which is defective and when I use it my clothes are spoiled, I can sue the manufacturer whom I have no contract. But why not here? The problem arises because of the legal perceptions of a house. The legal eye see a house not as a set of foundations supporting a floor with walls and roof, but as a single entity. To go back to the very beginning of negligence and Donohue and Stevenson's, the defective house is equivalent to the bottle of ginger beer with the snail in it. Mrs. Donohue was able to sue for the damage done by the ginger beer to herself, but not for the replacement of cost of the ginger beer itself. In other words, the ginger beer and the house constitute a defect. The English law will compensate for a defect in contract but does not begin to recognize a tort until the defect causes damage to something other than the defective thing itself. In the case of Anne's and Merton's London Borough Council in 1978, the local authority approved building plans for a block of flats and the flats were built later that year. However, by 1970s, structural movement have begun to occur in the property, causing crackings to the walls and other damages, causing the property to become dangerous. The claimant tenants in the flat began proceeding in 1972 in negligence against the council on the basis that the council had failed to properly inspect the building walls properly in order to ensure that the foundation were laid to the correct depth shown in the plan. There are two specific issues here. The first one is whether the council owned the duty of care to the claimants in respect of the incorrect depth of the
foundation laid by the third-party builders, and the second is whether the claim was statute barred. It was held that the council may be liable in negligence, but in limited circumstances. The relevant legislative provision with regard to inspection did not place a duty on the council to inspect the wall, but it did allow it to power to if it considered inspection necessary. Therefore, failing to inspect would not render the council liable unless it was considered that it had failed to properly exercise its discretion to inspect and that they had failed to ensure proper compliance with building regulations. If inspection were carried out, the council retained discretion as to the manner of the inspections. If this discretion was not genuinely exercised, the council may be liable in negligence. The claim was not statute barred, the limitation period running from the date in which the dangerous state of the property became apparent. However, in Murphy and Bradfield District Council in 1991, the defendant local authority had negligently approved plans for the footing of the house. The claimant purchased the property, but sometimes afterward it began to subside and a result of defects in the footings. The claimant was unable to afford the required repairs and was forced to sell the property as a loss. He also claimed damage for the health and safety risk which the defects had caused to himself and his family during the time they lived at the property. The issue was whether the claimant was on a duty of care with respect to the damage which he had suffered as a result of the defective footing which had been approved by the defendant. The judgment was that the Eng and Merton London Borough Council case did not apply. The House of Law held that as the damages suffered by the claimant was neither material nor physical but purely economic, the defendant was not liable in negligence. It was decided that to allow the claimant to recover damages for the money which he had lost on the sales of the property or for the cost of repairing it would result in an unacceptably wide liability which would effectively amount to judicial legislation introducing product liability and transmissible warranty for the defective buildings. As a summary, the issue of liability for defective premises lie at the heart of the battle for supremacy between torts and contracts. What dictates chance of success in litigation over defective premises owe more to wider issues of politics and jurisprudence than to the practicality or justice of a remedy on the particular facts of the case.
Recovery of pure economic loss has been permitted for some Commonwealth countries such as Australia, Canada, and New Zealand. Australia's High Court does not see instances of financial loss as a distinct liability category, but as part of the general law of negligence. Australia requires a close look at the proximity requirement for economic losses resulting from damage to a third party's estate. For example, in Caltex Oil and the Dredge, the High Court unanimously allowed Caltex's claim for the economic loss suffered when the negligence of the defendant rendered the pipeline owned by a third party used to transport oils inoperative. Next, Canada. The Supreme Court of Canada unanimously dismissed the restrictive perspective of liability put forward by the House of Lords in Murphy in the latest judgment of CNR and North Pacific Steamship Company. Canadian law may be somewhat similar to the Australian position in the sense that there is no important discrepancy between the liability imposed on the two jurisdictions. Like the Australian courts, the Canadian courts followed Hadley-Burns values carefully. Next, New Zealand. The New Zealand liability is the largest in scope compared to the liability imposed by other Commonwealth jurisdictions. New Zealand favours Lord Wilberforce's two-stage test in Anne's case, which was rejected by Australia's High Court and the House of Lords in England. The New Zealand courts have emphasized the concept rather than the precedent in creating the law on liability for economic loss. Like Australia's High Court, New Zealand's Court of Appeal handled instances of economic loss as part of the negligence of general law. Nevertheless, when determining the boundaries of liability, New Zealand has not always adhered to the principles set out in the determined instances. However, pure economic loss was not treated at the Court of Appeal of New Zealand as a separate category of loss, nor was it treated as such by the Supreme Court of Canada. In both jurisdictions, the Anne's judgment remains good law. In addition, for certain European systems such as France, the legal category is still not recognized, and pure economic or financial loss is not distinguished as an independent type of damage. Other European systems, particularly Germany and England, acknowledge the category and use it in the context of a liability-free law. Liberal systems like France create exceptions to the domain of compensable economic losses, and conservative systems provide sometimes compensation for losses that would otherwise fall outside the list of protected interests. What about Malaysia, our beloved country? In Government of Malaysia and Chia Fung Chiu and others, Wan Muhammad H., which described the decision in Murphy and those in similar cases as highly satisfactory and appropriate, the High Court of Malaysia gave its unqualified approval to the decision of the House of Lords in Murphy. Ken On and another, and Yeo and Wu Development, Sdn Bhd and others followed that. However, in Dr. Abdul Hamid, Abdul Rashid and another, and Jurusan Malaysian Consultants and others, the courts ruled that as a result of enabling recovery for pure economic loss will result in inhibiting carelessness and improving the manufacturing and construction. In Majlis Perbandaran Ampang Jaya and Stephen Fo Cheng Lun and others, the main Malaysian case regarding pure economic loss is the decision of the Federal Court. The principle laid down is that pure economic loss can be recovered if the defendant's breach is foreseeable.
The general rule for economic loss claim caused by a defective product is that a cause of action cannot be brought against the defendant for the claim of pure economic loss suffered by the victim. However, in the case of Annes v. Merton, London Borough Council, Lord Wilberforce established the liability to the defendant on the basis of pure economic loss caused by the defective product. There were several criticisms on the reasoning given to the Annes case as they seemed to be capricious. According to the speech given by Lord Wilberforce, there must have been a physical or material damage suffered by the victim in order to claim for economic loss, implying that there should be a latent defect manifested itself in some way. But a survey done to check the condition of the property is not good enough to bring the claim. Besides that, the reference of the defect to the health and safety need to be in the present and imminent is also vague in a sense that the claim would not be allowed if the danger caused by the defect is in the distant future, or the defect of the property does not cause any physical injury to the claimant. Thus, the distinction given by Lord Wilberforce is very questionable and does not set a clear path for future cases regarding pure economic loss. The ongoing debate on whether claim for pure economic loss caused by the defective property extended to the case of Murphy and Brentwood, where Lord Bridge pointed out that the test in Anne's case requires the risk or danger to health caused by the property to be imminent. Is very difficult to gauge if the claim is on the pure economic loss suffered by the party due to the defect. Thus, Lord Bridge came to the conclusion there is no claim for pure economic loss suffered by the plaintiff in this case. This raises the question of whether the general rule of no claim for pure economic loss is fair to the party who suffered such loss. Of Dutton and Faulkner Regis Urban District Council, the Court of Appeal characterized what appeared to be economic loss as physical damage and allowed the claim. In the case, the defendants' counsel argued that they might be liable if the ceiling fell down and injured a visitor. but they would not be liable if simply because the house was diminished in value. Lord Denning responded by saying that he could not allow such submission as it was not solely economic loss as there was physical damage to the house. If such a submission were to be allowed, then it would mean that the council is only liable if the defect caused damage to the party, but if the owner discovers the defect in time to repair it, and he does repair it, the council is not liable. The decision made in this case was affirmed by the House of Lords in Anne's case. This measure was to balance two opposing forces where on one hand there is a need to compensate the parties in compelling situation, whilst on the other hand, such decision might open the floodgate. Thus, the decision made in Anne's was well balanced in a sense that the claimant has to prove that the danger was imminent to the health and safety, narrowing the scope of claim. The test was extended to the case of Junior Books Limited and BG Company Limited. In this case, the dissenting judgment of Lord Brandon focused on the boundaries between tort and contract, which was in the roads into privity of contract, was very significant as the decision in Junior Books was overlooked by House of Lords in line with the argument of privity, and they followed the orthodox approach in the case of Murphy and Brentwood, limiting claim for pure economic loss for defective products under the contract grant. In conclusion, the pure economic loss caused by the defective products in the UK should stick with the general rule set in Murphy's case by not allowing such claim in order to maintain the consistency of the rule. If the claim was allowed, it might open the floodgate, which would increase the number of cases causing congestions in the court. However, if the court were to allow the claim for pure economic loss, there should be an Act of Parliament governing the amount of claimable loss in order to reduce the scope of the rule applied. The risk to the safety and health of the claimant caused by the defective product must be imminent and latent for the claim to go through. Thus, in order to claim for pure economic loss, the party must fulfill the requirements set under the statute, making the law more consistent and certain.
We hope you enjoy our video and thank you for watching.
Bye.